Sure, yes, Judge, no go.
Good morning, Mr. Child. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Out on bond for assaulting an officer and then caught with drugs? That's strike two and the judge knows it. Here's the question. Should someone who violates bond even get a second chance?
Officers were dispatched to a disturbance at 70 Carlton Woods Creekside. Law enforcement officers observed a white male sitting on the curb of Kukendall Road, arguing with his girlfriend on a cell phone. Law enforcement officers law enforcement officers had received an additional call of a disturbance of two individuals coming from a neighborhood party. They observed the complainant and defendant to be highly intoxicated. An Uber had picked them both up, and they both started fighting in the Uber. The Uber drivers pulled over.
Fighting in the Uber?
In the Uber, yes, Your Honor. The Uber driver pulled over. The Uber driver stated to officers that the defendant was slapping and punching the complainant, who was the defendant's girlfriend.
5 once and you're in jail. No excuses. Be real with yourself. Would you really risk 6 months locked up just to get behind the wheel?
Help with the situation. I'm sorry, Your Honor. This is reading directly.
DVD's here. I don't know if Sebastian's had a chance to even look at it yet.
Actually, stay close to that area, will you? Don't come here. Stay close to that area.
Yeah. Okay. Okay, sorry.
So we're just doing PC. All I've heard so far is that they're both highly intoxicated, arguing. He's allegedly punching and slapping in an Uber car. That's all I've heard so far.
Okay. So then Uber driver pulled over and called the security officer on duty. The defendant got out and started walking. The security guard followed him until he got to the beginning of the subdivision. Then officers arrived and observed the defendant on the sidewalk. Officer tried to talk to the defendant. The defendant started to tell the officer, quote, "Leave me the fuck alone. Your people are a piece of shit, and that's all you'll do is treat people with no respect." The defendant started walking towards the officer, dropped the pill bottles, and kept saying, "Leave me alone, get away from me." Officer asked the defendant what it was that they were trying to hide. The defendant said that that's my marijuana.
Judge says it goes in one ear and out the other. That's courtroom code for I'm done giving chances. At what point do second chances become wasted ones?
Defendant was combative, telling the officer to fuck off. Officer made contact with the complainant witness, said they were a party, they both got drunk and started fighting when they got in the Uber. And the complainant witness stated that she did not feel pain. I think that's what we're at.
Do they see any visible injuries, anything of this nature?
Okay, as far as that goes, what's in the DIMS here is that the witness stated that he observed the defendant with enough force that she covered her face, fell to the floor, and that the witness observed the complainant based on her actions to appear to be in pain. Specifically, that the punch was of such a force that it caused her to fall to the floor of the vehicle and covered her face after she was punched. I think that's where we're at with that.
Again, to answer your question, there's no indication that there were any injuries at all.
Probation isn't freedom. It's homework, classes, drug tests, constant check-ins. So ask yourself, does probation set people up to succeed or to fail?
Just read, she says she did not feel pain, she did not want to press charges, and I have an affidavit on prosecution as well that I'm going to be getting to the state.
Yeah, so as far as bodily injury goes, of course, we don't need necessarily direct evidence. Pain can be something that can be inferred based on conduct. We understand that, a punch of a certain amount of force from a witness's perspective.
Did they get any statements from the person who saw the punch?
Again, that was the Uber driver. And that's what the Uber driver said, that based on what they saw, the punch had enough force that it caused her to fall to the ground, covering her face.
The officer goes to interview the complaining witness, I'm
Yes.
assuming, and doesn't see
And
anything?
I don't see any indication that they saw anything.
And she says, I felt okay. And I do not want to press charges.
Mr. Child, there are people in life when they drink, they're the life of the party, they're fun to be around. And then there are those when they consume alcohol, they turn into aggressive, mean son of a bitch that have no business drinking. If this is you, don't drink. You have but one life. You start racking up cases, you start racking up convictions. All you're doing is you're hurting yourself. Be nice and good things happen. You're aggressive to cops. You're aggressive here. I mean, the only reason I'm finding no probable cause is because they wrote this report completely, just utterly terrible. And it's over and over and over. But don't drink if you're going to be in jail. Really. We have enough death and dismemberment in our city now as it is. Don't be on the news. All right, I'm going to find no probable cause.
Thank you, Judge.
I think it's driver's license. I know driver's license. On the state executive.
Good morning, Ms. McKnight. Ma'am, you're charged with 2 cases. You're charged with criminal mischief, and you're also charged with interference with the emergency request for assistance. On the criminal mischief, you're facing up to 6 months in jail and a $2,000 fine, and on the interference case, you're facing up to a year in jail and or a $4,000 fine. I also see she has an open warrant.
Yes, Your Honor. I see that as well.
You also are charged with, I guess, the following day, you picked up a terroristic threat. On that case, you're facing up to 6 months in jail and or a $2,000 fine.
How did that tell me?
First, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to
How
you.
did that take?
Let's do probable cause and then we'll.
On April 13th, 2025, officers were dispatched to a disturbance. Dispatch stated that the defendant knocked the complainant's phone out of her hand and then left the location. Officers made contact with the female matching the description given by dispatch. The female stated that she was the victim, that she was not talking without a lawyer. Defendant gave name and date of birth, but would not provide an ID card. Defendant was detained and taken back to the incident location. Complainant stated she reported a criminal mischief on the defendant the day prior. Complainant advised to dispatch that he would later call back and report the incident, which he received video of the incident proving that the defendant had damaged his vehicle. Complainant advised today he went to the store, and when he returned, the defendant was on his porch. Complainant asked the defendant, "What are you doing here?" After you broke my window of my vehicle. Complainant advised he told the defendant just to sit there while he called police. Defendant then left, but returned while he was on the phone with dispatch. Defendant knocked the phone out of his hand and caused damage to the phone. The value of the phone was $300.
And what about the terroristic?
So the terroristic threat, Your Honor, this is the same complainant. On April 15th, officers were dispatched to a telephone harassment. Upon arrival, officers spoke with the complainant. Complainant stated that he had received a phone call from the defendant via a Google phone number. threatening to shoot up her home. The complainant stated she was confident the caller was the defendant and expressed her desire to pursue criminal charges. Further investigation revealed that the defendant had been arrested at the same location on April 13th for interference with an emergency call and mischief. She was out on bond for that incident.
She been given conditions not to go back.
Let me check here.
Open felonies stacking up. The judge calls it a revolving door. But now it ends. Here's the choice. Quick pull. Rehab first or lock up first.
If there's probable cause to go forward with the case, I don't want you to have contact with this person.
It's not for them. I'm praying about that.
I don't want you to have contact with this person. Do you understand? Or you understand?
Yes, sir.
Okay, I don't want you to go where this person lives. If you do, it's not going to go well. I will revoke your bond, put you in jail. Do you understand?
Yes, sir. I have evidence for all that.
And I'm going to give you a lawyer today. I know that there's two sides of the story. You can give your side of the story you can give your side of the story to the lawyer, but I don't want you to have contact with this person. That's it. Do you understand?
So when it comes down to the child, do I have to come back to court just to get in contact with us?
I don't want you to go to his house.
No, I'm talking about, do I have to come to court so I get in contact with him because we have a child?
We'll figure that out. Let me get you the lawyer and then we'll figure that out. But just don't go to the person's house. Don't have contact with him. Don't call him. Don't use anybody else's phone to contact him. It's not going to go well. You need to understand that if I revoke your bond in these cases and I set them at $5,000 to $10,000 and you don't have anyone to post those bonds, you will be stuck in there until these cases are over. Do you understand? Okay. Deputy Miranda, you mind? You know what? Don't even worry about it. I'm going to appoint you a lawyer today. I'm going to have you sign a reset with Victoria and then we'll have you take a seat in the jury box while I find you a lawyer. Don't leave until you sign our bond conditions.
In your article,
Okay.
you want to wait for the lawyer check to set bond on the new case as well.
Yeah, I guess so.
Yeah, you don't need to ask you here for the rent. Right? Yeah, see?
Yeah, okay.
I mean, as long as the parents are some bond conditions.
Yeah, I was over here.
So, you ready?
Yes, sir.
You are Mr. Saran. Sir, you're charged with criminal trespass up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Law enforcement officers received a call for service where an individual stated that somebody was trying to break into her home. Officers observed the defendant matching the description given by a caller around in the area. Officers made contact with the defendant and he was identified by previous booking videos as well as his SPIN number. Officers made contact with the complainant on scene, who advised that the defendant was trying to break into her home. Complainant stated the defendant knocked on the front door, rang the doorbell, and looked through windows of the complainant's property. Complainant observed the defendant enter her backyard, stand on top of a shed to look into windows, and attempt to pull on a door handle to open the door.
It's only a trespass.
Another bond violation in 6 months. That's the legal version of game over. Should the judge still show mercy? Or is it finally time for jail?
Property, officers searched the defendant and found an unused pipe. That officer's training experience indicates it was used for meth. Defendant stated he was a frequent user of methamphetamines. Defendant further stated that during an interview with officers that he was looking for items of value at the above residence in order to obtain money for drugs since he was currently out of money. And I think that the reason it wasn't charged as a bird hat is because he wasn't actually able to make entry into the residence.
Mr. Saran,
Yes, sir.
since 2023, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and now 11 in a matter of 14 months. If I find that you're using any kind of dope, I'm going to take care of it in a way you're really not going to like it. I'm sending you now for a drug and alcohol test because I want to know what, if anything, is in your system. You're ordered not to use anything, and if I find that you do, and if I find that you become a danger to my community, I will grow a horn and tails. Do you understand?
Yes, sir.
I'm putting a GPS monitor on you so I know where you are at all times, and I don't want you out in the middle of the night.
Yes, sir.
It's time for you to stop using. I'm giving you now the opportunity to do it on your own. If you're incapable of doing it your way, then we're going to do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
Please appoint him a lawyer. I'm sending him now for a drug test. You were to go test, and you were to come right back. I just want to know what, if anything, is in your system.
Yes, sir.
If you fail to test, if you fail to come back, I will issue a warrant. No more PR bonds. Do you understand?
Yes, sir.
Take a seat for me.